And now we're going to take up draft number 1.2 of S45, and going to be a little out of order because I understand Steve Collier has a hard stop at 11. So we'll have Steve, if you could join us and introduce yourself and also weigh in on the draft number 1.2.
Yeah, good morning, and thanks so much. Steve Collier from the Agency of Agriculture. I was actually laughing at myself on the way over here. Since I have something in the middle, I realized I had to be first or last. And if any of you have seen a certain movie, if you ain't first, you're last. I'm glad I get to be first. So thanks so much for sharing the proposed changes. And again, really appreciate all the effort the committee's putting into this issue. I know it's kind of a novel one for a lot of folks in here, but we really appreciate it. I think I was planning on just kind of walking through this.
That'd be great
if that works.
Yeah, that'd be great.
Just to start, I think I just put it on the record that we do prefer the bill that passed the Senate, but we also believe that these changes are thoughtful and reasoned, and that if you incorporate some or all of them, it will still be a vast improvement to where the law is now. So either way, we appreciate whatever work comes out of this committee, and definitely think this is a tremendous improvement from what exists currently. So I don't know, I have some extra copies if anybody wants a paper one, but it looks like everyone already has one. So I think the first suggestion I would make is on page 3. And it's so understandably, Mr. O'Grady added concentrated animal feeding operations because if a farm has a CAFO permit, then there's Title 10 requirements that are distinct than if they don't. We can get into that discussion if you want. It's called CAFO. It's a concentrated animal feeding operation, and all farms are covered by our agency currently. If you are discharging, there's a Federal Clean Water Act requires that farms who are discharging have a federal concentrated animal feeding operation permit. There aren't currently any in Vermont, which is not particularly unique. But if a farm does have a concentrated animal feeding operation, then ANR would regulate the farm through the Clean Water Act. So I don't have a problem with this suggestion. I think one thing I might do, though, because if we're adding this, then I think it might be better to make it clear that it's applicable, because most farms are not going to have a CAFO permit. And I don't want a judge to be looking at this and trying to decide if the CAFO permit requirements apply, even if the farm doesn't have a CAFO permit. So a suggestion would be on line 6, where they talk about the Agency of Agriculture permits, perhaps including applicable permit in that line, because if you have a CAFO permit, you may not have a permit with us. And it makes sense. And some farms don't have a permit with us anyway. So I think just clarifying that you're only beholden to the permit requirements if you actually have one is useful anyway. And especially if we're adding CAFO permits, then that's even more useful. And then
I'll go Ken, this question.
Did you say farms don't have these already, or they do?
Currently in Vermont, there's no farm that has a federal CAFO permit.
So why would they want one, and then they have ANR watching over them even more?
Well, they may or may not want one, but the ANR has a right to compel one if they're required under federal law to have one.
And what exactly do these things do?
They do the same thing that our permits do. They require farms to institute a litany of practices that prevent discharges to water. It's really whether you're under state permitting or under federal permitting, it's almost identical. It's just that federal law controls when you have a discharge, and if you don't have a discharge, then state law controls. So this is not changing. This would not change anything about whether or not a farm needs a CAFO permit. That's a separate discussion that's happening, and that's why I have to go at 11. In a different committee, but this would just be incorporating that if you do have a CAFO permit, a federal CAFO permit, then one of the things you would have to show is that you're complying with it. And given what we've done with general agricultural accepted practices, I don't personally have a problem with that. I mean, if you have a CAFO permit and you're not complying with it, that's akin to having a LFO permit or a large farm operation permit with us and not being compliant with it. I think that's a reasonable change to make if you in fact have a federal CAFO permit.
Okay, thank you.
Sure. But what I would suggest putting on line 8 is when it says the requirements of a concentrated animal feeding operation permit, I'd suggest prefacing that with an active concentrated animal feeding operation permit, just to be clear that it only matters if you actually have one at the time, because someone could have one and then no longer have it, or it just, I just think having it clear that it only applies when it applies and not just generically. So then on the good standing with the state definition, which starts on line 15 on that same page, I would suggest that a couple of things. One is changing the ordering at the end of the Agency of Ag and Secretary of Natural Resources, and only because I think it would be wise to preface the requirement for A&R to say related to a CAFO permit, because A&R could have a lot of different things that they're issuing violations to a farm on that may have nothing to do with the water quality regulations. So I just think it makes sense to specify that if you're talking about proving good standing with A&R, it's related to your CAFO permit, not just any other thing that might be out there. And then another thing I would suggest, and this is very similar to language that our agency already interprets, but currently we're the ones who interpret it, so we know how we interpret it. And the way we interpret it is if you have a final order, then you're not in compliance. But once you resolve everything that is required of that final order, you are in compliance. I think the way this is written, that's how it should be interpreted. But since a court might be looking at this and not have any idea what a final order is or any idea about administrative enforcement, I think it might help to be clear that to put at the end that it's something that a final order that is not otherwise fully remedied and resolved, some language to that degree, just to be clear that once the farm meets the requirements of the final order, it does not continue to preclude them from access to the defense, or not even the defense, the burden. And I don't have a Word version right now, but if you want, I could ask Mr. O'Grady for one, and I could put all of these suggestions in a version to send back to you, but I wanted to see if you're even interested in any of them first.
Thank you.
So then the next one for the definition of nuisance. So at the end of the first clause on line 21, it stops with a reasonable use and enjoyment of land. There's a whole body of case law that defines nuisance that can be helpful for sort of addressing what's actually required. So if we're going to define nuisance in statute, I might suggest that we add at the end of that clause as defined by common law, so that you're not narrowing or expanding unintentionally what a nuisance actually is, because that precedent can be helpful. But then also putting and also, so after the comma, and also includes the things that Mr. O'Grady suggested. So that way it's clear that it's broadening and not potentially a narrowing of what nuisance protection is. And then I didn't get a chance to think very comprehensively about the list, but I might suggest something like adding to that list, something like other liquid or particulate matter. So, because the whole idea of nuisance is you're operating on your own land, but you're bothering somebody else on theirs. And so anything that's coming from your land could arguably, through the air, I think that encompasses liquid, I think would be through water, which is a different discussion. But I think by taking trespass out of this bill, in my mind, you've addressed the legitimate water question, which if a farm changes the water flow in their property drastically, if a farm reroutes a river so it goes into your house, that's pretty clearly a trespass that ought to be actionable. But if a farm is doing everything with their manure management, their fertilizer management, doing everything appropriately and is not changing the water flow in any way, then personally, we don't think that should result in a nuisance action, just because a neighbor could argue that their water is now contaminated. Well, if that's true, but the farmer is doing everything right, and that's a policy question for you, but why give a private right of action for that if the farm is already doing everything that federal and state law requires? But that's different. The trespass invasion of land, disruption of land. So if you're changing the water and substantially increasing the flow of water, you're disrupting someone's land. That lies in trespass, not nuisance. But I would just like to close the gap on a neighbor can claim that you're polluting land because E. coli is in the water, even though the farm is doing everything's right. We all pollute every day. And so, when we flush the toilet, we're polluting. When we drive our cars, we're polluting. When we go to the grocery store and take the food that's arrived to us, we're polluting. When we throw out our garbage, we're polluting. So there's pollution and then there's pollution controls, but we do control the pollution, and setting somebody up for a private civil action when they're doing everything right doesn't, from our perspective at least, doesn't seem like the best path. Obviously, people can have a different view on that.
I think that one is one that probably will have different views on, I would imagine. That's the heart of a lot of this. That's what you just mentioned. But okay, I understand what you're saying.
To be clear, not all of us will have a different view.
Not everybody will. That's suggested.
So then the next suggestion is page 5. Page 5, starting with line 3, and it's really about, so there's this idea of proving good standing, and I just think it would be helpful for a court to look at this to understand what proof is required, so there isn't a lot of litigation about that. For the mediation, the S45 proposes a sworn statement. I think it would be helpful to either say you want a sworn statement, at least as an initial burden, so you know that the defense is in effect, or it could be a letter from, A&R and our agency, or some combination of both. But I just think it would be better not to create a lot of litigation over what that proof entails. And especially since if that's considered to be a dispositive burden of the defendant, that could lead to more litigation about what you have to do. But if you're clear that a sworn statement is enough, or you're clear that a letter from either one of our, both of our agencies are enough, then that can be easily remedied with the court without a lot of extra work. The next suggestion is on page 6, top of it. So this is another kind of shot at the water issue. We do not, if the committee intends to narrow the definition of nuisance, as we discussed earlier, I don't think this does anything extra. And I think it actually probably makes it quite a lot more confusing. So if you're taking water trespass out of the equation, then I don't see why this would be required. And I do think if you're taking it out of the equation, but then sort of potentially bringing it back in, that creates some of that circular confusion that we're trying to avoid by making it very clear like what farms have to do and what they can't do. So that's just a suggestion. If you want to narrow it, we'd recommend that you do it as you did by defining nuisance to be a bit more expansive than common law, but not then further narrow it as it's not necessary. A trespass is different than a nuisance. And if you're not addressing trespass at all, then this isn't a protection for trespass. And I don't think you probably need to further define it.
Unless, again, adding the other liquid to the nuisance list might cause some confusion unless we put this in there. But we'll take more testimony and think about that some more.
No, that's an important point, and agree that that's sort of the crux of the matter. And I think what we would suggest is that trespass is a physical invasion and a change to damage to the land, and nuisance is how you define it. So if you're talking about particulate matter, that's not been ever considered in Vermont a trespass. Particulate matter. It has been. The Supreme Court was asked to consider it a trespass, and the Supreme Court said they did not in that case, but they didn't definitively rule on it. So I think from our perspective, what you're trying to do is give the court clear direction and the parties clear direction on what's actually a nuisance in this realm and what's a trespass. So if you're saying it doesn't include particulate matter, then a droplet in a stream is not going to constitute a nuisance. But if you're actually damaging someone's land by increasing the water flow or ripping it up, that's a trespass. So there's a lot of ways to do that, but our strong preference would be that nuisance being included to include invisible matter, that is not, certainly was never in the common idea of nuisance. And we're asking that we be clear now that folks are bringing more, bring different and novel claims to understandably to try to get around protection. So I think the next thought that we had was, sorry. Oh, there's one on page 7, line 18. I think you want to take out the word trespass there if you're going with it, just a typo. There's one thing on, so the mediation piece, I don't think I remember talking to the committee about this, but you all should know that at least currently the U.S. Department of Agriculture offers free mediation to farmers in disputes with neighbors. So right now, any farm that has this kind of dispute could go to free mediation. So it wouldn't cost anyone anything. With the things that are happening in the federal government, I don't know how long that will be there, but it's been there a long time and it does exist now. And we hope that it will continue to be there.
Do you have any view? I mean, the concern that was raised was if this mediation like carries on and on and on, and there's ongoing damage or nuisance, how does this kind of process, how can it be time limited?
I mean, the way that I read it, that it's been written, is it's an attempt at mediation, which means, both parties have to try. There's nothing, in my mind, if you go to a day of mediation and you can't reach an agreement, it's not even a day. It's parties can withdraw from mediation at any time, and there's no way to enforce them not to. It's a voluntary process. You would be telling them by doing this, you have to meet and try. There's no judge, I don't believe, who would say you have to try harder. There's already a mediation process in civil court. Once you're there, every court in Vermont requires parties to attempt mediation. This is just a chance to avoid court, because court involves expenses and significant expenses. So if both parties try, I mean, actually, if a farmer refuses to mediate, a plaintiff can go to court. You can't compel someone to meet. So that's enough. There has to be an attempt to mediate. So if a neighbor says, I want to talk to you about this, and please see this statutory provision that requires this before I file suit, and the farmer says, go pound sand, I'm not talking to you, then the neighbor just files an affidavit with the court and says, I attempted mediation, and the farmer refused. I mean, I don't think it's any more onerous than that. And it shouldn't be. I mean, it should be an effort. But to call once and nobody picks up and you just say, well, I tried, I don't think that's enough. The message has to be relayed. So then on the prospective application, understand why you're doing this, or considering doing it. I'm uncomfortable with well, I want to say 2 things on this. One is understand why you're doing it. It's really frustrating that the parties who've come in and talked can't find a solution to their dispute. And we feel horrible for the farm. We'd love for the plaintiffs to find a solution as well. This is something that's been incredibly expensive for both sides, and it's ongoing. And we've talked to both parties many times. We would really love for them to find a solution. I'm not suggesting this legislation is a way to find that solution, but I really do hope the parties find a way forward that works for both of them, because it's really destructive, and it may well lead to the loss of that farmland to development. And I don't think that's good for anyone. But we don't have a solution. We've tried to propose solutions, but there is no way to stop water from flowing downhill. So it's an ongoing issue, but we understand you're not trying to address that case, but we do kind of encourage both parties to think proactively about how they can find a resolution so that they can live harmoniously. The piece of the language, the broader piece of the language that kind of I'm concerned about is on line 4, shall not affect any right, privilege, obligation, or liability acquired, accrued, or incurred. I'm worried that's going to lead to litigation for at least the next 6 years, or when the statute of limitation is there, about a claim already accrued prior to the effective date. And so parties may claim that doesn't really take place for 6 years. And I don't know if it would or not, but I think it creates that window. And if what you really want to do is make sure that no pending litigation is impacted by this law, I think you've already done that with both the first and the last part of this section. So I would suggest if you really just want suits that are filed to be impacted, to leave it there so that if somebody files a suit on July 5th and you pass this law, it's still clear where the burden lies. And that it wouldn't mean that you couldn't talk about past acts, but the burden of proof would be on the plaintiff now. So I just suggest that change. And that's it for our thoughts on it.
All right, any questions for Steve in the last 7 minutes that we have him? Oh. Yeah, go ahead.
This will give you a clue as to where I feel my general confusion about this issue currently. Could you summarize for us how this version of the bill improves upon the current statute from your perspective?
I mean, significantly. And it does that because it defines first of all, it shifts the burden of proof, which is really important especially if you're trying to defend yourself against a frivolous lawsuit. It can mean that you might be out of court in 6 months instead of 3 years. So, or 4 years or 5 years, some of these cases. So shifting the burden is really important because it makes the plaintiff say what's wrong. And if they don't have any evidence about what's wrong, then the farmer has a chance to get out early. If they do have evidence of what's wrong, it's going to take time. The other important thing is it defines what's expected of farmers. So it says, farmers, you must comply with the water quality requirements. Farmers, you must comply with the pesticide requirements. And farmers, you must also use proper accepted customs and standards. So it sets, and proper accepted customs and standards still has that, vagueness and big ambiguity that we discussed, but we agree, we think it's probably appropriate to have some balance so that if there's something that's not specifically regulated, there's at least a litmus test about what's appropriate or not. So it tells farmers and neighbors what has to happen. And those are no small burdens. I mean, there's a lot of regulation. So there's a lot of ways that a farmer can be doing 98% of things right and still be subject to suit under this because they're doing 2% of things wrong. And that's not a super comfortable place for farmers to be, no matter what. This is not perfect, but it at least defines what it is. The current rubric does not define it in any way. The farmer has all this burden to prove that they were there first and they didn't change anything and they're complying with every law under the sun. It's just an incompatible standard. So this tells courts and the parties what applies. And so that's really important to defining what the actual standards are. And it shapes the litigation. If you've got broad, expansive litigation, it takes more time, more money, more effort. You need more experts. If you can narrow the issues quickly and know what matters and know what doesn't, if you're going to have litigation, you at least have a clearer path through it. So, yeah.
So I do want you just to explain again the difference between nuisance involving another liquid, which I also count as water, and trespass, because I'm still not clear.
So what I think you're trying to do now is to expand the definition of nuisance, or at least arguably expand it to encompass particulate matter that might be considered a trespass. Odor starts in the manure pit, spreads to other people. You can make a claim that odor is invading your land, and damaging your land, and so that is a trespass claim. I think what you're trying to do is say, no, that's not a trespass claim. What I've suggested is that your list could be a little more expansive for the things that we're not considering, which is particulate matter. So that's kind of, as I understand it, kind of anything in the air. So that if you're talking about smoke is already listed, but there are maybe other particulate matter that we're not thinking about that could be included. So you're incorporating that.
Yep, that one makes sense.
The reason for liquid is, and maybe I didn't explain it very well, but if you have all farms have some runoff, right? When it rains, water runs downhill. So even when you're doing everything perfectly appropriately, you're still going to have some runoff from your field, whether it's through surface water or groundwater, there's some. That's allowable as long as you're managing everything appropriately because you're limiting, hopefully there's zero waste coming off that runoff. There may be zero waste or there may be some waste, but it's legally allowable as long as you are managing it correctly under this, litany of comprehensive regulations. So what I'm suggesting is that if a farm is doing everything correctly, but there is still some waste coming from runoff, but it's meeting federal and state requirements, that there shouldn't be a private civil action for that through nuisance. Now, trespass that's an invasion of something more than a droplet of water or a droplet of E. coli. That's taking over a property, stopping somebody from their physical invasion. There's nothing about water flowing downhill that does that in and of itself. Like I said, if you reroute it into someone's house, that's a traditional kind of water trespass. Is that you're actually you're damming or you're rerouting, you're expanding, and so the flow on somebody's land is significantly changed. So that's what I'm trying to articulate, and maybe not very well.
Yep, I got it. Okay. All right.
So I'm wondering if the way you're proposing changes now, would it cover any testing? Well, I know there was testing of the water, but testing either the sludge or whatever it is, particles, to see if there are harmful chemicals in there that would have a negative health impact, either immediately or over time to neighbors.
That's a great question. No, it wouldn't cover the testing of them, but as an example, farms have spread biosolids on their fields for years. And that's something we're very concerned about. A lot of farms are very concerned about. They were encouraged to do so. They were paid to take it. And now that we're learning more about PFAS, that's a real risk that there may be PFAS in those biosolids. I think that the suggestion that I'm making would protect them from a claim that PFAS leached from their soil if they did everything appropriately and went downstream in a nuisance action. I don't think it would protect them in something that's an actual trespass and recognized as a trespass.
Right.
A case that has civil damage, damages.
This has nothing to do with personal injury.
Right, yeah, okay.
If you're alleging that you drank contaminated water and you got cancer, this has nothing to do with that. This is property claim. This is use and enjoyment of your property.
And as the federal landscape changes and there may or may not be federal standards, wouldn't it, I'm concerned when you said if they are meeting federal, and I think you said state, not or, but if we don't have federal standards someday, it seems important that we have state standards that are evidence-based, that we feel good about, so that we can protect Vermonters no matter what the federal government decides to do.
And in this realm, the state standards are virtually identical to the federal standards. I mean, basically what the state did back in, I think it was 2004, was they took the Clean Water Act, which only applies to discharges into federal waters. They took that and they expanded it to state law under state non-point source pollution. So that currently every Vermont farm is subject to those state law standards. The only way that could change at all, and they'd still be subject to the state law basic standards, but if a farm was discharging and required a federal CAFO permit, then they would have to get a federal CAFO.
And are you aware if any states have protections that are greater than the federal standards in place?
Well, we do. Ours are much greater because in federal law only applies if you're discharging. Ours apply regardless of whether you're discharging.
How about other states? Do other states also put in extra safeguards?
Yes, we have one of the, as I understand it, and I haven't researched every state, but I'm quite confident that we have one of the most robust series of water quality protections anywhere. Vermont is very environmentally protected.
I believe you probably have to run to.
That'd be great. Yeah.
So thank you very much. So we will go Scott Sanderson next, and we'll have Mike clean up. Does that work for you, Mitch?
Thank you very much.
Yeah, thank you, Steve.
Morning, everyone. All right, if I start?
Yes, please do.
Fantastic. Chair Lalonde, members of the committee, thank you very much for inviting me to join you a second time. I'm sorry that I can't be there in person today. But for the record, my name is Scott Sanderson. I'm an attorney, and I'm the director of Conservation Law Foundation's Farm and Food Program. I also manage the Legal Food Hub, which is a service that connects income-eligible farmers with free legal assistance and legal resources. And much like Attorney Collier, I'd like to thank you for all the work that you've done on S45. I think the draft of the bill makes a number of really significant improvements on the previous draft. And so examples of that, I think it's great to remove trespass and directly addressing damages related to flooding and water pollution. Those changes address, I think, my most significant concerns with the previous version of the bill. I will note that the draft's mediation section continues to include trespass, and I think I'd recommend removing that so that the bill remains focused on nuisance in the new draft. I'll also highlight that I think that attaching nuisance protections based on a demonstration of good standing, that seems to strike a reasonable middle ground. I do have a couple of suggestions. The first one is that I continue to think that it would make sense to allow a plaintiff to overcome the extra protection that a nuisance suit, the extra protection from nuisance suits, if they can demonstrate that the harm that they allege meets some heightened standard related to health or safety. There are lots of states that do this, including Arizona, Kansas, Nevada, Washington, New Hampshire, Wisconsin. They use language that is somewhat similar, but narrower, so more protective of farms than Vermont's existing language. And they usually make the bar something like a significant adverse effect on health or safety. I think the committee could incorporate this kind of a standard in section 5753C. That's where the negligence component of the bill is, and just add something like, or has a substantial adverse effect on health or safety. And I think that would satisfy that concern. The second thing is that I think the draft's inclusion of requirements for concentrated animal feeding operation permits in the definition of generally accepted ag practices, I think that makes a lot of sense. I also think that the current definition does a nice job of including regulations that are relevant to nuisance. I think it may be worth considering whether there are any other regulations that should be included in that definition to true it up with the kinds of harms that you might have in a nuisance scenario. And the reason that I mention this is that potential nuisances on large farms are already regulated by the large farm operation rule, which would get drawn into the generally accepted ag practices definition under the, I believe it's the 6 VSA 215 part of that definition. However, for medium farm operations, so the medium farm operation permit and the required agricultural practices, they don't include similar provisions that are right on nuisance related issues. And so that means that there may be a gap in the generally accepted ag practices definition when the farm involved is raising up to 700 cows. I think that in that situation, you would end up in the sort of catch-all provision of the generally accepted ag practices definition. And so I think it's worth exploring there. I'm not sure whether there are Vermont regulations that are exactly on point for farms of that scale, though. For example, I'm not aware of Vermont applying air quality regulations to farms. And that may actually be a good question for Attorney Collier or Attorney O'Grady. I just don't have the expertise there to make a concrete suggestion. And then I'm in a similar vein to one of Attorney Collier's suggestions, though with relevance to a different section. I'm not sure that section 5753B is necessary given the bill structure. That's the section that, well, so as I read the draft, changes in a farm's practices, size, and scale already would not disqualify the farm from protection, because the protection attaches as soon as the farm is able to demonstrate good standing, and it can't lose that protection unless a plaintiff shows that the ag activity complained about doesn't meet the definition of generally accepted ag practices or has something related to negligence. So as far as I can tell, considerations related to size, scale, timing, those sorts of things wouldn't factor into right to farm decisions and nuisance protections decisions under this bill. So that may just be an extra section as I read this.
So where is that
I-
again?
Where?
I'm
That's
not
on
sure I'm
page
following you.
6.
This
So
is
that's on
six-
page, it's on page 6 and then line 12. So section 5754, subsection B. And that's where an ag activity shall not lose its nuisance protection due to things like a change in ownership, change in crops produced, change in farming method. And I'm not sure that that's necessary because the protection under this bill would attach as soon as a farm is able to show good standing, and then the farm could not lose it except in line with except if the plaintiff can show that the farm doesn't meet or the activity complained about doesn't meet the generally accepted ag practices standard or is conducted negligently. So I'm not sure that these would be issues I don't think that these would be issues that a farm would have to contest with anyway.
So you're talking B 1, 2, and 3, that whole.
Yeah, I don't think that those are necessary, and I don't think removing them would change the degree of protection available to a farm. I also want to address one of the suggestions that Attorney Collier made related to the definition of nuisance on page 3, line 20. If I understood correctly, Attorney Collier suggested expanding this definition to include nuisance as defined by common law. I think that given the committee's concerns around flooding and the addition of the protection and the addition of the carve out for flooding, water pollution, things like that, I think I would want to check on how expansive Vermont common law is with respect to nuisances. My concern here is that it is possible, though I don't know for sure, that Vermont has included many things that are very classic trespasses, things like flooding, and has allowed them to be dealt with as a nuisance. And so my preference would be to leave the nuisance definition here as it is. I think it's quite clear. Of course, you could make those adjustments for things like particulate matter. But I think that there is a potential for unintended consequences if that nuisance definition is expanded with common law, and if Vermont common law has a very expansive idea of what nuisance is. And then if you were to also simultaneously remove the provisions on page 6, so page 6, line 1, this was, I believe, another of the suggestions from Attorney Collier, and that's that the nuisance protection provided for under subsection A shall not affect the right to recover from injuries related to water pollution, pollution of groundwater, and flooding. So that combination of those two changes I would be concerned about, the potential to expand nuisance to include things like flooding, while simultaneously pulling out this provision that is, as I read it, is meant to expressly protect a plaintiff's right to bring an action like this related to flooding. And that's most of what I have. Again, I'm very appreciative of the adjustments that the committee has made to the bill, and I'm happy to answer any questions.
Yeah, Angela.
Thank you. So I just want to make sure I'm understanding what you just said.
Yep.
Are you saying that the common law definition of nuisance would include flooding? But then
I'm saying that I don't know.
Okay.
And it's possible, but that it's possible that it could. And so I think it's worth checking on whether it does, because under this definition of nuisance, if you were to include the common law definition, and the common law definition included things that we generally think of as classic trespasses, because maybe Vermont courts were trying to create multiple paths there, then this definition of nuisance would it has two halves, right? So it expands, it says what a nuisance is, and then basically says that you can't bring a trespass claim for something that this chapter would define as a nuisance. And so if you do those two things and then combine that with the provision on page 6, or sorry, combine that with removing the provision on page 6 as Attorney Collier suggested, that may get you into a situation where you're extending this protection to things that generally look like trespasses even after removing trespass from this bill.
Thanks.
So I want to explore that definition of nuisance. It seems that if we also add interference from liquid, you're back at trespass. But having said that, I mean, I'm trying to maybe thread the needle here that we're okay with just your standard runoff. It's kind of the excess water from whatever a changing farming practice that could be problematic. So, I mean, let me just throw an idea out there and shoot it down. And if you don't shoot it down, Mike O'Grady will. I mean, if we add something like interference from, that it includes interference from runoff or natural runoff, or just say interference with runoff, and then have a separate definition of what we mean by runoff, which is your standard water going downhill. I don't know if that's something that's workable. That I'm just trying to capture that nuanced difference that I was trying to understand from Steve Collier.
It's an interesting question. I think the challenge that you may have with runoff. So I'm trying right now in my head to parse the difference with drainage versus runoff. One of my concerns would be related to overland runoff that is carrying with it things like manure or pesticides or things like that have been spread on the land. If it's sort of the incidental runoff situation where it is like you're describing a trickle of water, just sort of the normal kind of runoff that you would expect to come off your land, I don't see a problem with that. I'm not sure how to define the line between that trickle of water and a drainage related or sort of large scale type of runoff or that is caused by farm practices or land management or things like that.
People could continue to think about how we might be able to distinguish that could be helpful. Are other questions for Scott? Don't see any. Yeah, go ahead. Yeah.
Just to kind of try to get at your question, is part of the challenge, Scott, as you see it, that my phrases were kind of running through my head, and one of them is naturally occurring, but everything that we're talking about could be naturally occurring, right? Things that were
No, not everything that you're talking about could be naturally occurring. So, for example, a lot of drainage on farms is not naturally occurring, right? Farmland is altered in ways that change the amount of water that is stored in the soil. So, for example, if you add drainage, if you add subsurface drainage, you're actually changing the total volume of water that is going to be drained. It's not that water, so each particle of water that's there will eventually drain downhill, but by adding drainage, you can completely alter the size of the sponge that the land is. And that's one of the main goals, right? When you add drainage, you're trying to dry out your land quickly so that you can either protect the root zone of your crops or get out on a field earlier than you otherwise would be able to be. There are a couple other reasons too, but in any case, you're basically cutting off part of your sponge. And that means that the total amount of water that you are exporting from your land changes. And that's due to your management practices. So I don't think I'd characterize that as natural. It's part of the proactive management that farms do to change how their land deals with water.
All right. Okay. So but yes, but runoff is naturally occurring. I don't know, I'm struggling, I guess I'm struggling with the same.
Yeah.
Thing that you're struggling with and, trying to figure out if we can acknowledge that. Well, I don't know, maybe this is for community discussion. I'm just.
Right.
How do you not,
Hmm.
I don't want to say punish, but well, no, but if someone is actually doing what, caring for the land and caring for the farm and trying to do everything right and like. There is an element of naturally occurring even to drainage because it's water.
Right.
I don't know how we really read that,
Right.
Oh, actually, I think it's getting into discussion, so.
So, yeah, no, we can have that momentarily if we can have that with Mike on the seat. But John, did you have anything to add? Are you good with, since you're here?
Yeah, no, I'm just grinding in my mind, like, I think everybody is.
If you could identify yourself for the record as well.
Sure, I'm sorry,
No.
John Groveman, Vermont Natural Resources Council. I mean, I'm just thinking about and trying to parse this in a way, and it goes to your question, Representative, that, you don't want to, if people are harmed, it doesn't have to be, if you could be complying like the PFAS example, like this is what we talked about years ago when we talked about PFAS liability. Those regulations are not great. They're still not great. And there we said, hey, people get access to courts, even if you were complying with whatever the government regulations are, and there are lots of gaps in the toxic regulations, you should be able to try to get to court and make your case. Trespass and nuisance are and negligence, all of those are the common law claims that are used in those situations. And I think we just want to make sure that people will be able to pursue that if they're really harmed. One of my thoughts is that if it's so small, people won't be harmed, like they won't have a case, if it's really just regular runoff or naturally occurring runoff and it doesn't cause a problem, then you have no case, you wouldn't,
Right.
But I mean, I want to think about, I just wrote myself a note to think about what you said and talk with Scott, but I do think it's hard to parse,
Okay. All right,
if
well,
that makes any sense.
we'll keep on trying to parse that. Yeah, Karen.
Can I just ask a question?
Yeah.
Since we opened up, do you have thoughts on all of the changes? Are you going to be coming to share that? Or I know we were focused on this little piece.
I mean, I agree with Scott. I think it's a real good step in the right direction. I was heartened to hear Attorney Collier, say that it still helps to fix, like I said, when I testified in the Senate, the big issue was the presumption, and this fixes that, and I think creates some clarity over, for common nuisance actions, what a farmer has to prove to show that they're meeting practices. So I do think that this is really headed in the right direction. I think this last issue is the issue. And I share Scott's concern that we don't want to take out trespass, but then put something in that kind of causes the same problem. But otherwise, I think it's a really positive direction on the drive.
Don't need to hear me, but
Good. All right, great. So Mike, can you join us and comment on what you've heard so far? And I'll have specific questions as well. I guess I don't know that you need to do a walkthrough at this point. So, unless folks want to have Mike now do the walkthrough even after we've had the.
I feel like a walk, I always like to hear how.
Yeah, why don't you do the walkthrough that we were gonna have you do an hour ago, but because
I
of
think I
timing
might have
and
been less confused during testimony if we'd had the walkthrough.
apologize for that, timing of witnesses.
Very well.
And I'm sorry to get here sooner, but
No, that's fine.
we're actually doing the CAFO bill downstairs.
Right.
You know what that is, Matt?
So this is Mike O'Grady, Legislative Council. I'm going to walk you through draft 1.2, that's 45 of an April 2nd date and 1:07 p.m. Sam. You're still in that chapter, the existing chapter entitled 12 related to nuisance suits. The findings and purpose section is not changing. Definitions section is changing. as you were already discussing the standard for what is a generally accepted agricultural practice, it's adding the requirements of a concentrated animal feeding operation permit. To address Representative Goslin's question from earlier, why would a farm want that? I don't know if a farm does or doesn't want it, but they may be required to get it because US EPA has said that ANR has not been adequately administrating and enforcing the Clean Water Act for discharges from farms. It has ordered ANR to implement corrective actions to take on the authority to permit discharges from concentrated animal feeding operation. But regardless of whether a farm wants it or not, they may be required to get it because of EPA's corrective action.
That's nationwide.
The permitting program, the permitting requirement for CAFOs under the Clean Water Act is nationwide for every delegated state. And there's only two or three that are not delegated. But different states do it differently. And so there are concerns that Vermont's ANR program hasn't done anything, but literally has not issued a CAFO permit since they've had the authority to do so. And that's why EPA has entered and ordered corrective action.
Thank you.
So I do want to comment on Steve's point about whether it should be, say, an active CAFO permit or the requirements of the RAPs where applicable. I think that he's right. There's not going to be a CAFO permit for every farm. So especially if it's not a livestock farm. And so having an active requirements of an active CAFO permit, I think that makes sense. The RAPs apply to everyone, regardless. I don't know if you need to say where applicable, the RAPs apply. So I have a little bit of objection to that. Moving down page 3 in the new definition of good standing. This is based on the definition of good standing that the Agency of Agriculture already uses in 2 different places in law. I see Steve's point about having it clarify that it's not resolved, but that's not how it's addressed in statute currently right now. I might be able to massage this language to address his concern without maybe doing it the way that he suggested, but I can try to do that. But I just want to note that it's not done in the 2 places where it's currently in statute already. Then in the definition of nuisance, I'm a little cautious about saying as defined by the common law. I don't know the full scope of that. I'm sorry, because it is 150 years or more case law precedent, and I don't know whether or not it's ever been applied to water. I don't know if it's ever been applied to aerosol liquid. I don't know. So, and I looked through the statutes to see where nuisance has been referred to. It's like this shall not create a public nuisance, or this is a public nuisance. It doesn't say as defined by the public law. It just says it's not a nuisance.
Right.
Yeah.
So I agree with that, but I also, it's like, we're using the word including, and I understand under the way we do statutory interpretation is that means including but not limited to.
That is correct.
So presumably that door is wide open, whether you change that language or not, for whatever courts have found to be nuisances.
Right. That is correct. And the including language is there to address that issue that you discussed the other day, the Hawaii language. This is the Hawaii language of not allowing someone to use the same set of facts, but just to characterize their claim differently to circumvent the nuisance protection. And I mean, that's a policy decision if you want to do that. Taking out trespass maybe raises that policy concern a little bit more because you no longer have the protection against trespass, and someone could then just like, oh, because the particulate matter entered, then that's a trespass. So I see both sides here. I can see concerns on both sides, but it's about what you want to address. And I think adding particulate matter makes sense to the list. I don't know if you need to add liquid because, well, I have a way to address, potential way to address the liquid concern.
Good.
In
I think that's the biggest.
None of us do.
Yeah.
What is it?
But I want to get to that when we get to it on page 6, if that's okay.
Yes.
And then moving on, bottom of page 4, the core changes in 57, 53 on page 4, they remain the same, except you are removing trespass. The standard is still no agricultural activity shall be or become a nuisance. And the activity is conducted in accordance with the generally accepted agricultural practices. So it's still that, there's still, as all of the witnesses have noted, that need to define what the common accepted practices are for the purposes of the protection. And that does give a plaintiff an opportunity to say that the activity isn't within the traditional norms. I do think that that's a very common standard and a very common way for states to provide right to farm protection. Moving on page 5, lines 3 through 7, in the provision about good standing, I think a letter from the agencies that they are in good standing is very easy to get, and very easy to demonstrate so that court doesn't have to determine what the final order is, where the final order is, etc.
Do we need to put this into the statute though, that the or is that just going to be understood by court process?
Well, I originally assumed it was going to just be assumed by court process, but you heard Steve Collier say that he is uncertain of that it will be. I think a court could easily say to the defendant, provide us a letter from the Secretary of Agriculture and the Secretary of Natural Resources that you're in good
It just seems a little odd for us to like narrow the scope of how they would show that or just spell it out. It's what's kind of my, if it seems like it's going to happen.
There's already the definition of good standing is that they're not subject to a final order. I mean, all you need to do is contact the agencies and say, am I subject to a final order? And they can give you a record of that. Probably be provided in an email.
Ken, and then Angela. And then Barbara.
You're saying if they contact anything to do with this state, I think that's what I heard you say, it would be pretty easy for them to get a permit?
No, it's not a permit. It's to remember what's being added is that in order for the farmer to show or even to claim that they have the nuisance protection, they need to be in good standing. It's their activity can't be subject to enforcement. The activity that's causing the nuisance can't be subject to enforcement, and then they claim nuisance protection for it. Like if they're being enforced against for this agricultural activity, they shouldn't receive nuisance protection for that activity. That's the basis of the good standing threshold. You don't get to be a bad actor and get the nuisance protection for the activity that you're being subject to enforcement
So I think I got you. I think I understand what you're saying, but I don't think there's any agency that's going to just go and like send an email out without going on the property and going and checking everything out.
No, because this isn't about what's ongoing. This is about whether or not there's an administrative enforcement action that's in the courts already against this person for the agricultural activity. That is something that can be documented, in my opinion, administratively easily. If I were the attorney for a farmer who knew he was in good standing, she was in good standing, I would contact Steve Collier and say, there's a nuisance suit brought against me. As you know, I need to show that I'm in good standing with the agency. Can you send me a letter that says I'm in good standing?
Okay, I'll respectfully disagree with you because I don't think there's anything easy that the state is just going to go and sign off on anything without inspecting. I'm going through that same process right now, or have been going through it for years. So I think in the land of being sued so easily and covering your bases and all this stuff, I think it's going to be a much longer process than that. That's just my opinion, and that's my concern.
Would it help you, Ken, if we put some specific language in here that a letter from these agencies showing good standing is sufficient for that showing?
Well, it
Does
would
that
help.
help?
Well, it would help. It would help, Chair, but I think bottom line is a lawyer is still going to rip it apart. My opinion.
Your good opinion.
I think the lawyer probably who's going to represent the plaintiff isn't going to try to attack the agency's determination that there is no final order. I think they'll attack whether the activity was compliant with the practices conducted in a manner consistent with proper and accepted customs and standards followed by similar operators. I think that's where you're going to have the dispute. And I think that has been acknowledged because there is no standard out there that defines what all the practices conducted. You're going to have testimony about, is that an accepted practice? Is it used by similar operators in the state? I think that's where attorneys are going to have their disputes.
Which is exactly what we're dealing with right now in this bill.
Yes, you are dealing with that, but you're changing the standards of how to deal with that. You're, for one, shifting the burden to the plaintiff because under the current law, it arguably becomes the farmer's duty to show that they're doing everything correctly. Now the plaintiff has to show that. In addition, you're taking away the ability to overcome the nuisance protection by showing that there's some standard that has been met, like you're significantly harmed health, etc. That is no longer there. You are in my opinion, you are moving Vermont's right to farm while further along the spectrum towards more protective of the farmer. You are not removing any opportunity for a plaintiff, a neighbor, etc., but you are providing more protection to the farmer without removing all protection for the neighbor.
So two things in this bill that really makes me have concerns about this is the certain farmer that we've been dealing with a lot supposedly meets Agency of Ag requirements, and the University of Vermont went in there and set all this stuff up, and it's became more of a problem from probably two of our best assets.
Well, that's a great reason or a response to that is one of the reasons why you're putting in the good standing threshold is to address that issue. The court in that case, when it was argued, because right now compliance with the RAPs is part of the standard, you have to comply with those RAPs. And the farm said, oh, we're complying. We've never had an enforcement order against us. And the court said, well, that doesn't mean you're complying. And so by having that good standing order, you are in good standing. The activity at issue here is in good standing. That you are not subject to an enforcement order. You're not subject to enforcement. I think you're clarifying how to show that you are complying with the RAPs. But maybe UVM said, oh, this is beyond the RAPs. You need to do something such as this to address your field conditions. And maybe that was the standard for those field conditions. And that's when you come to the question of whether or not the practice is conducted in accepted customs and standards followed by similar operators of agricultural activities in the state. And they would just have, there would be testimony from both sides in that situation, evidence, etc. But the farmer can show that, but even under the current law, even if the farmer showed that, the plaintiff could then overcome that and say, oh, even that you showed that, I have a significant adverse health effect from the activity that wipes out that nuisance protection. And the court said that. The court said, like, even though they were following proper practices for their manure management, even though they may have built their manure pond appropriately, even if they did all of that, the plaintiff could show significant adverse health effect, and therefore the nuisance protection is gone. This bill doesn't allow for that anymore. This doesn't allow for that anymore. You heard Scott say maybe you should allow for that, but currently this draft doesn't allow for that.
Okay, for now. Thank you.
You're welcome.
Angela, then Barbara.
So I was wondering if there's any reason not to be as clear as possible in terms of,
The letter.
spelling out the letter, the requirement. I know there are reasons to leave things up to the courts and wanting to provide latitude and discretion. But given, I just wondered in your opinion and understanding of current statute, current issues with that statute and what we're trying to address, it seems to me that clarity is one of the goals here. So I wondered if in this particular case.
Right, for a farmer or somebody looking at this, maybe just add in the sentence that this may be proven by obtaining a letter from, or statement, letter, whatever you want to use from the.
Okay, I think.
As well.
Okay.
And then Ian.
So some of this, I think you explained when you're talking to Ken. But so I'm wondering, the generally accepted agricultural practices, when you read what the definition is, and which one I Googled it and pretty much found verbatim what you said. How does that work with the EPA saying Vermont is not, it's generally accepted in Vermont, but the EPA is saying you're not doing this well?
Well, that is why the language about being compliant with the CAFO permit and the CAFO requirements was added, because if there is a determination that the farm is discharging, it's going to need that CAFO permit, and you will want them to be complying with that. But the CAFO permit is only water. You might be dealing with something like management of waste. You might be dealing with management of animal mortalities. You might be dealing with pests. You might be dealing with vectors. And the CAFO in the EPA doesn't address that at all, but the common practices and how you deal with those would.
Okay. And I'm trying to just sort out in my head. I know this came up early in testimony a few days ago, that Vermont is primarily a dairy state, not so much pig farms. And if we became a pig farm state, things would be very different. And in reading about like the dangers with pig farms, I'm like, whoa. So if Vermont started becoming more of a pig farm state, what would happen, like if this is our law?
So let me ask it slightly differently because it was a
Okay.
question I asked yesterday or
Okay.
whenever that was.
Okay.
And that is just using an example. What if an organic vegetable farm decided to change to a pig farm? And I'm troubled if this says you can't bring a nuisance claim, even though it's pretty significantly different and the impacts on the neighborhood are probably significantly different. I think that's along the lines of what.
Yeah,
just to
yeah.
give
I mean,
give a
it's
specific
opening the,
example.
right, that's a great example.
Well, the definition of agricultural activity that is cross-referenced from Title VI does allow for a change in operation, change in equipment, change in type of farming. And that is reflected in the purpose of this entire chapter, where it says that
But I guess, I mean, I can see would be a little different where you're starting to use a practice that injects the manure or those kind of things. I mean, it's like a different kind versus a significant difference from a organic vegetable farm to a pig farm.
well, it's hard. Let me just step back.
Thank you.
So farms have difficulty just being one kind of farm. That if you're just a dairy farm, you're subject to the milk market order and the pricing under the milk market order, and the milk order doesn't always reflect your cost of production. Honestly, it doesn't reflect your cost of production in Vermont. So farms have always been encouraged to diversify, get a maple stand, started an excavation business, have a forest stand where you can get either your firewood or you can sell firewood, have a vegetable garden on your farm as well, and have a farm stand to provide that do bees and sell honey. They're always encouraged to have multiple income streams, and you've even furthered that encouragement by allowing accessory on-farm businesses in the past 5 years or so. And so they look to change. They look for opportunities. They want to be able to do things like maybe I'll start raising pigs. If they ever got to the threshold where they needed a CAFO permit, a medium or a large CAFO permit, you would probably have your town in revolt at that point, because the number of pigs that is a medium farm is 2,500. If they weigh over 55 pounds, it's 3,000 to 9,999 if they weigh less than 55 pounds.
3,000?
So 9,900. That's a medium swine farm. A large swine farm.
But all right, my point, you don't go there, but so my point being that if they go to a medium pig farm from their organic vegetable farm, they're gonna have significantly more impacts. And would,
They'll have significantly more impact. They will have significantly more agricultural water quality requirements. An organic vegetable farm has to do some stormwater management underneath the RAPs, but not nearly what a livestock farm, a pig farm would need to do. That pig farm would need to control all runoff coming off of its production area. It would need a nutrient management plan, and pigs create a lot of things that need to be managed under a nutrient management plan. And it's to say, oh, they're going to just go from that vegetable truck farm to a farm where they have 1,000 swine. I don't think that is as viable as an action in Vermont as you would think.
I was just using it as a hypothetical.
Okay, so
Although I do have, look, I do have the Cody versus Ramsey Associates case.
I can give you some examples of where things have happened. Small farm, southeast Vermont, doing vegetables, doing honey, doing maple syrup. They started cutting wood, and their neighbors did not like it because they were cutting wood whenever they had the opportunity to cut wood, including like at 9 o'clock at night. And was that farming? Well, no, because processing timber is not farming. It's not an agricultural activity. It has its own nuisance protection, but it didn't qualify in that situation. You know, so there are changes that do occur. Sometimes it does involve an agricultural activity, sometimes it doesn't. The best example, and probably one of the reasons why some of the farms want this protection, is the case Trickett's versus Ox. They were an apple farm, apple orchard. They were in operation for years, but they changed their packing. Not what they were doing, they just changed their packing. And their packing was louder, and it allowed them to do it at night as well. And the neighbor who had moved in just a couple of years before sued. And the courts originally said, yeah, it was a nuisance. Like, they didn't qualify because they changed their practice. And that change of practice occurred after the neighbor moved in. And that really terrifies farmers because they have to innovate. They have to do things like manure injection. They have to do things. Well, let's step back. They didn't do liquid manure 40 years ago, 50 years ago. It was dry. They field stacked it. And the concern was that when you put manure out in the rain and just let the rain fall on it, that it's going to run into the waters, and that maybe you should collect it and then deal with it according to and that's why you have honey wagons. That's why you have sprayers. That's why you have injectors. It's because they changed the practice because they thought it was better for the environment and better for the farm.
Right. And those are fine. I'm worried about the ones that significantly increase the impact to the new development that has just been built.
Health issues.
Yeah, well, the health issues, I think we have covered. Health issues are, I think we need to talk about substantial effect to health or safety, but are you good, Barbara? On that?
I mean, so one thing I'd love clarification on is, like, when you want to open a childcare center, you have to get licensed, and there are like very, it's not just like, how do you feed the kids? Like, there are lots of different licensing regs. I'm a little confused about this fee, like if I wanted to become a medium pig farm, would it be pretty prescribed, all the things I have to do? Or like, is this feed I forget what the acronym is. Yeah, is that like, are we only talking about how we're feeding? I mean, yeah,
If you were going to be a medium pig farm and you didn't want an A&R permit, you would have to do everything that the Agency of Ag dictates so that you don't have a discharge. And honestly, with 2,500 pigs, you're probably going to have some discharge, and which means you're going to have to get the A&R permit, and you're going to have to do everything underneath that permit, which is everything underneath EPA's rules. So controlling the discharge, managing your production area, managing your land application of nutrients and manure. You would have to do all of that. But there is no license. This isn't like Canada where it's a system where you have to buy into your
right. No,
into your right to farm certain commodities.
I'm just thinking more of the human service delivery, not Canada.
Right.
But I'm wondering, let's say I was like, the hell with that. I'm gonna do it anyway. It sounds like the EPA thinks Vermont isn't holding people accountable. So how long can I get away with annoying my neighbors and not getting the
Well, technically, A&R already has the authority to require the CAFO permit. They are required to, under the Clean Water Act, to respond to every complaint of a discharge. If there was a complaint of a discharge, they're technically required to go out and determine if there's a discharge, and they have the authority right now to require a permit. Now they are looking for changes, both from your House and from the Senate, about how they exercise that authority and the extent of it and flexibility in doing so, compatibility with the Federal Clean Water Act. And you'll likely see a bill on that.
Ian and then Andrew.
Just very briefly on good standing and the notice. I'm trying to stay out of hypotheticals too much, but I don't understand this process well enough without using a hypothetical. But with the language currently proposed, if a nuisance claim was brought by a neighbor and that notified one of these agencies of an issue and they began an enforcement action, would the farm be able to use this presumption?
I think that's really going to be fact dependent. I really do think if the plaintiff says this activity is causing an issue, the farmer says, I'm going to go get a good standing letter. The agency says, oh, we had a complaint from the neighbor too, and we went out and we think you're violating. I don't think they're going to issue a good standing letter.
Okay, that's because the language here says final order.
That does reflect something that Steve said. It's that, and you might get a different response from different agencies. Is that they do try to work with farmers to correct issues, and you've actually written that into the statute for ag water quality, that you directed them to go through a process when dealing with the farmer to give the farmer opportunity to cure it. Because sometimes during this season, the farmer can't cure because the ground is frozen or the situation cannot be addressed at that time of year. So you do tell the Agency of Agriculture to give farmers some time, but there are some things that they are allowed to immediately require correction of. And that's where you might see a different interpretation from the Agency of Ag and the Agency of Natural Resources. So I can't, it is, it could happen.
I only ask because it just sort of seems like, while that's hypothetical, I can sort of see that happening like every time, like there was a nuisance argument from a neighbor or a nuisance complaint from a neighbor, that they might go to the agencies and complain. And then so like if that's happening every time, like.
Well, I mean,
Yeah, that's.
what is often a big issue with farms and livestock, it's odor. It's from land application or just your manure lagoon in the summertime. And as I said the other day, you really, it's an experience. You should just like go and just like experience it. And it does have a smell, but that is what they are dictated to do. That's what, if they are managing inappropriately, if they are, that is what they're supposed to, that is the accepted conforming practice. It's gonna smell. It's gonna smell.
Yes. So it's almost noon, doing a time check here, and we have more to go over with you.
Yes.
So
Can I just jump to the water? So
well, let me ask you this. What is your availability after the floor or after the floor tomorrow morning? Because tomorrow, I understand there's nothing on the notice calendar and it's going to be, except for announcements, very short. And we could be back in here by 10 if you're available in the morning tomorrow.
I am not available in the morning tomorrow, and I was scheduled earlier today to be in house environment after the floor. Actually, after I get a new laptop, because my laptop wants to explode.
Or we can go for another 10 minutes or so, if that's okay with folks.
Sure.
Can I quickly?
But you answer your question.
Just,
Yes.
well, I want to confirm with you, Attorney O'Grady, that all of these hypotheticals that we're talking about and just farming in general is a regulated practice and industry. Like I feel like that is almost getting lost. Like maybe not, but just in some of the conversation, like farmers are already required. We know there are wraps, there's like all kinds of things that are.
Right. It depends largely on the practice that you're engaging in, but the general base standard is the RAPs. And some will say that they're not adequately enforced, and some will say that they're more stringent than any other state.
And in any change, as you mentioned the other day, in any like major change in an operation, there would be a bunch of layers of probably.
Yeah, there could be, especially if you're dealing with livestock. If you're going to be increasing your numbers, say you're got 25 cows and you decide you're going to go to 60 cows. Well, now you need to be a certified small farm, which means that annually you need to send in a document that says you are complying with the RAPs. And then say you want to go, I want to go from my 60 cows to 212 cows. Well, now you're a medium farm, and now you need a permit. And now you need to apply for the general permit or get an individual one, and there are additional requirements for you, plus additional, more frequent inspection. So there are, as you expand in livestock, especially dairy, you are going to trigger review by the Agency of Agriculture. And now, if you're a medium farm or a large farm, A&R is going to go out and do an inspection of you over the next 4 years to determine whether or not you have a discharge and you need a concentrated animal feeding operation permit. And then anytime there's a complaint, the agencies are supposed to go out and determine whether or not there's a discharge. And for other types of complaints, pesticides, smoke, odor, you're putting your manure too close to my line. They do go out and try to address those issues as well. Is it perfect? No. Is there specific granular enforcement of a change in use? No. No one's going out to make sure that the combine harvester that you got isn't louder than your last one.
Right.
Right. And so
They're not.
Pardon?
You said they're not?
I'm just saying, I said, no one is going out to determine whether the new combine harvester you got is not louder than your old one.
Okay, thank you.
So go to page 6 in the water, and though I would like you to consider before you get to page 6, the bottom of page 5 and C, adding something along the lines addressing the substantial effect on health or safety.
You do want that.
Yeah, I think that
Okay.
is, that part's.
And I will probably, Scott said Arizona, it literally is like 5 words, substantial effect on health and safety.
Right, so page 6, sub.
So I'm just going to kind of jump into it, and I'm going to assume you all remember the conversation that you already had. So one of the things that
Go for it, go for it.
one of the ways that commonly water issues are dealt with, water coming off of your land onto another person's land, they determine whether or not you've made any unreasonable alteration on your land that has caused an increased flow or increased pollution on your neighbor's land. You could build a standard like that into this language where you are taking some sort of unreasonable action on your land. So if it's just normal runoff, it's just normal runoff. But if you've taken some sort of unreasonable action to change the flow or increase the flow, then that is not going to be protected. It is a factual dispute. You're going to have attorneys arguing whether or not it was reasonable or not, but it does allow for that argument that any general flow off my property should not be considered a nuisance or
Right.
trespass.
Well, that's what we're trying to get at, but my only issue or question on the unreasonable flow is that, does that tie back into farmers saying, well, I followed this RAP and therefore it's got to be considered reasonable?
I do think you'll have that discussion. You will have that discussion. Or I went to the UVM and they told me that this is how to do subsurface tile drainage, and this is how everybody in the area does subsurface tile drainage. And what I did wasn't unreasonable.
And the reality for like how these suits will get filed is that I'm going to make an interesting question. Do you think it might be the reality with how these suits get filed that they'll just plead trespass and nuisance, and they'll just argue the facts on both and try to get either it as a trespass or get through the nuisance on one of the exceptions?
There's a case in Indiana where the plaintiff argued like 7 different claims: nuisance, trespass, negligence, inversion, like all these different claims. And the court said they're all a nuisance claim. The court said, I'm not going to let you argue all these different things, different claims based on the same set of facts. Is every court going to do that? Probably not.
Yeah.
And there's different sets of facts that will allow for different claims. So but if you're it will depend on if it really is about odor, if it's really about dust, it's really about how in the summer you can't go to your little beach because it smells. I think those are traditionally nuisance, and you would have protection for that or need this bill.
Last question.
Okay, whoa, okay, so I didn't like.
Make it good.
I appreciate that suggestion, the reasonableness standard, because is it fair to say, after the question, that is the conversation we should be having? That can be figured out in court, be unfortunate if it came to litigation, but Otherwise, might we be opening farmers up to penalty for doing what they think they're supposed to do?
I think that that's the anxiety that is in the farming community right now, that they are complying with their permit. They are talking with their consultants. They're talking with the institutes like Minor Institute. They are, I know one farmer that talks to Penn State Extension like pretty regularly, like, how should I do this? What should I do? Doing those things that the experts and the common industry is implementing, and then they're going to be sued and penalized for that. I think that is anxiety within the community.
All right, so we'll have an updated version, either 1.3, 2.1, I don't know how that works, on Tuesday afternoon possibly.
Yes.
I mean, given some of the possible changes that we'll look at. Thank you very much, Mike, I really appreciate that. And we're adjourned until Tuesday at 1 o'clock.